buckle up because today we're talking about indigenous nations and the reality of federal Indian law. Now, if that sounds like boring legal jargon, let me reframe it for you. Imagine you own your own home. It's fully paid for, it's spacious, it's yours. And one night you see a family stranded on your front porch. They're starving, they're freezing, they're helpless. They have nowhere else to go. So you do the humane thing. You invite them in, you feed them, you clothe them. You teach them how to survive the winter, how to grow food in the garden. You basically save their lives. But then they get strong, and instead of saying thank you, they change the locks and evict you from your own home. And it doesn't stop there. They force you to live in the backyard shed. And then the ultimate insult, they make a bunch of rules on how you're allowed to live. And that new rule book, well, that's federal Indian law. It's the messy, fascinating, and maddening relationship between indigenous nations and the federal government. It's an ugly settler colonial system where the guest, the settler, became the landlord. So how does that actually work today, and why does the US government have so much say over indigenous peoples? Let's find out. The first concept you need to understand is sovereignty. In the most basic terms, it just means the right to rule yourself. Indigenous tribes had this right long before the United States was ever created. Indigenous nations created their own laws, had their own leaders and borders. But when the United States Supreme Court looked at the situation in the 1830s, they came up with a strange definition. They called tribes domestic dependent nations. Okay, let's go back to the house analogy. The guest, the United States government, the settler, basically said, okay, you're still a nation, you can run things inside your shed, you can elect your own leaders, you can have your own police, but you are dependent on us for protection, for survival. And you can't make any deals without our permission. Yes, tribes can make their own laws, but they can't print money and they can't sign treaties with other nations. Make no mistake about it, tribes do have some sovereignty, and here's a perfect example. The COVID-19 checkpoints. In 2020, during the height of the pandemic, the Cheyenne River tribe in South Dakota was terrified. They had a vulnerable population and a limited health system. So the tribe set up health checkpoints on the road, entering the reservation to stop the virus from coming in. The governor of South Dakota was furious. She essentially said, you can't do that. That's a state highway. But the tribe said, actually we can. We are a sovereign nation. We have the duty to protect our people, and you do not have jurisdiction here. It was a standoff, and guess what? The checkpoint stayed. That is sovereignty in action. It's the power to say no to the state government. Now that's the state government, but with the feds, it's a lot different. You've probably heard somebody say, why does the federal government give Native Americans free health care and free education? Why do they get these special treatments? To understand the relationship between tribal nations and the federal government, you have to understand treaties. These are legal binding contracts. The law of the land. The United States government basically said to tribal nations, we're taking your land, we're taking your resources. In exchange, we promise to protect you, to provide healthcare, education, and housing. This is called the trust responsibility, and it's not welfare. This is rent. The United States government took the land from tribal nations and made promises. Now, all these treaty agreements, in one way or another, were all broken. They never fulfilled their responsibilities. However, when you see Indian Health Services, IHS, or the Bureau of Indian Education, that isn't charity. That is the government paying a mortgage on the land they're living on. Now there's 575 federally recognized tribes, and they're all living under these federal Indian guidelines. Now, if you're not a citizen of one of these 575 federally acknowledged tribes, you do not have access to any of these federal resources or programs. Now let's circle back to the trust responsibility, because it's important to note that the United States government holds the legal title to tribal land which is held in trust. In the eyes of the law, the United States is the trustee, and indigenous tribes are supposed to be the beneficiary. Under federal Indian law, the United States government has three main trust responsibilities. One is protection. They must protect tribal lands and sovereignty from outside neighbors like predatory corporations or state governments. Number two, asset management. Since the United States technically holds title to the land, they are legally required to manage the timber, the minerals, the resources like water on that land for the tribe's benefit, not their own. Number three, service delivery. They are legally bound to provide the things promised in those original contracts, the treaties we spoke about earlier, like the Indian Health Service or tribal schools. Here's the catch. The United States government is the only trust manager in the world that gets to make the laws. This is like the fox guarding the henhouse situation. The United States has a legal duty to act in the best interests of tribes, but they often struggle to do so because they're also trying to act in their own best interests. When those two things clash, that's when we end up in the Supreme Court. Now, here's where it gets messy. There is a glitch in the system, and it's called plenary power. Plenary is a fancy word for absolute. Even though the United States is supposed to be the trustee, looking out for the best interests of tribes, the United States Supreme Court has ruled that Congress has plenary power over Indian affairs. This is a massive contradiction. How can you be a sovereign nation if someone else has absolute power over you? And throughout history, Congress has used their plenary power to terminate tribes and even give land back. This is a constant tug of war. Tribes are always in court reminding settlers, the United States government, that absolute power doesn't mean they can ignore their trust responsibility. Now let's talk about jurisdiction. Who has the power to punish who? In the rest of America, if you commit a crime, the local police can arrest you. It's pretty simple. In Indian country, it's a maze. For a long time, if a crime was committed between two native people, in Indian country, it was handled by the tribe. But then, in 1885, Congress passed the Major Crimes Act. This was a massive use of plenary power. Congress basically said from now on, if a major crime like murder or arson happens in Indian country, the tribe doesn't handle it, the federal government does. This stripped tribes from their power to handle their own legal serious matters. It created a system where today, if you're on a reservation, your life is governed by three different sets of police: tribal, state, and federal. And it all depends on, are you native? Is the victim native? And did it happen on trust land? The biggest shakeup to this maze was the McGirt case. For over 100 years, the state of Oklahoma was acting like the Muskogee Creek Reservation didn't exist any longer. But it did. In 2020, a man named Jimsy McGirt pointed to that Major Crimes Act we just talked about. He said, "I'm native and this happened on a reservation. Only the federal government has the power to prosecute me, not the state of Oklahoma." The United States Supreme Court looked at the old treaties and agreed. The Creek Reservation had never been dissolved. The Supreme Court ruled that the state of Oklahoma had no jurisdiction over this case because the alleged crime happened in Indian country. This court case was a huge win for tribal sovereignty, and overnight, half of the state of Oklahoma became a reservation again. And the state of Oklahoma lost the power to prosecute certain crimes involving Native people. That power moved back to tribes and the federal government. So you can see how plenary power can work for and against tribal nations. If you take away one thing from this Indigenous Studies Masterclass, being Indigenous is a political status, not a racial one. So remember, tribal communities are not racial groups. These are actual nations. When you hear about laws like the Indian Child Welfare Act, which is supposed to protect Native children, it's not about race-based preference. It's about tribal citizenship. Indigenous peoples were citizens of nations long before this country ever came into being. I know the relationship is confusing, it's messy, and it involves a legacy of land theft and genocide. But here's the positive. Despite Plenary Power, the Major Crimes Act, and all these laws meant to limit tribal sovereignty, Indigenous nations are still here, still thriving. And they're holding the federal government responsible for the broken treaties and the land theft. All right, y'all, this is Dr. B. Thanks for watching, and don't forget, you're skating on native land. See you in the next one.